Hi guys, welcome back to my channel. So we finally have some news about the parole in place for undocumented spouses. The new parole in place program will begin on August 19th. The form is not available yet, but it will be an online only application. So there will be no paper application. Everything will be purely online. Starting August 19th, you will be able to locate this form in your USCIS account. Previously, we talked about the requirements for this program and we will go over them once again. I will link this specific page under this video where you can also find a link to the guide that they posted yesterday. This is kind of like a step-by-step guide for this application. So the application fee for this form is $580 and there are no fee waivers for this form, which means that you must pay a full application fee for this form. And if this form is approved for you, only then will you be able to apply for employment authorization by filing the form I-765. But you cannot file these forms together at the same time. On Monday the 19th, USCIS is going to hold a virtual session about this application. I highly encourage you to attend this virtual session if you have any additional questions. It will be held from 1 to 2 p.m. Eastern Time. You don't need to register for this event. You just click on the link. Let's look at the guide that they posted, which was very nice of them. Usually they don't post preliminary guides. They do tell you that you need to file a separate application for each relative. So for example, if you have an undocumented spouse and an undocumented stepchild, you will have to file a separate petition for each of them. So they do guide you when you log into your USCIS account, select the form. You must select the form I-131F. They do talk about the eligibility for this program. So non-citizen undocumented spouse, they have to be in the United States for at least 10 years since June 17, 2014, and they have to have been married to you already before June 17, 2024. You're going to have to prove your marriage is legally valid. You're going to also prove that you have clean criminal history and you don't pose a threat to national security or public safety. This application will require you to have a lot of supporting documentation. They also note on here that if you are currently in removal proceedings or if you have a 601A provisional waiver going, you also can still qualify for this application. So when you get started on the application, so if you are the undocumented spouse, you're going to create your own USCIS account to fill out this application. And then if you are an undocumented stepchild, you're going to have to file this application from your USCIS account personally as well. If at the time of filling out this application for a stepchild, you already have submitted an application for the undocumented spouse, you will provide the receipt number of their application as well, provide the current legal name of the person applying for this parole, and any other names that you have ever used. So if you are an undocumented spouse, you can write your current married name as your current legal name. And if you have ever used any other names on documents, you will provide this name here. Now, this is also going to be very important for the purposes of you proving your eligibility for this parole, because at the end, I will show you that you will need to provide a lot of supporting documents. And perhaps if you have resided in the United States illegally for the past 10 years, right? 10 plus years, maybe you used aliases or other names on other documents. So you're going to have to indicate those names here. Then provide your current phone number and email address, your current mailing address, and indicate if your mailing address is the same as your physical address, Moving on, provide your date of birth, country of birth, and country of citizenship or nationality, and biographic information such as gender, ethnicity, race, height, weight, etc. They will ask questions about your A number. Most likely you're not going to have an A number unless you maybe attempted to apply for applications. So for example, if you are applying for a provisional waiver or something like that. Your social security number. Likely you're not going to have a social security number because in order to apply for a social security number, you have to prove to the Social Security Administration that you have some sort of status in the United States. And do not provide social security numbers of people that you have used because that is illegal. And your USCIS online account number, you may not probably have one. Then they will ask you a qualifying question about your I-94 record. The I-94 record is only given to people who were legally admitted to the United States on a non-immigrant visa, so you probably don't have one. And if you do have one, so say for example you did enter on a visa and you overstayed a long time, this program is not for you. This is only for people who entered the United States without inspection. Provide your marital status, date of marriage, then provide the information for your United States citizen, spouse, or step-parent, their date of birth, and their social security number. They probably have a social security number, so indicate it here. Then it asks you a very important question. When did you begin your continuous presence in the United States? So in order to be eligible for this program, you must have started your continuous presence in the US beginning June 17th, 2014 or earlier. But you need to have been here at least 10 years as of June 17th, 2024 when this program was announced. It will ask you if you have ever been in any removal proceedings. If you currently are in removal proceedings, you will need to provide documentation of that. If you are in removal proceedings, I think it is best that you don't do this application by yourself and you do it with a lawyer. It will ask you if you've ever been arrested, convicted, etc. And they do tell you to not include any traffic violations unless they're alcohol or drug related. And then they will ask you if you have ever been arrested for, charged with, or convicted of any other crime other than the United States. And if you answer yes to any of these questions, I don't think you should be doing this application by yourself. And first and foremost, contact an immigration attorney. To be eligible not only for this program, you also have to prove that down the line you will be eligible to eventually apply for adjustment of status, to legalize your status, right? And one of the requirements of that is good moral character, which means that you don't have any criminal violations. Next, they will ask you if you have ever filed the I-601A provisional presence waiver. So if you are already in the process of that, that is fine. You still can go ahead and continue with this parole in place. Then, this is the most important question, and that asks you to explain to them in great detail how and why you should qualify for this program. They gave you a minimum of 750 characters and a maximum of 2,000 characters to explain how you qualify. 2,000 characters is barely one full page of writing. So you are going to have to not only be detailed, but also concise at the same time with your response to this question. And you're also going to have to explain why the United States society will benefit from you continuing to live here. Perhaps you are doing a job that is beneficial to US society. You maybe have family, you have children that you are providing for. You're going to have to explain it to them here in this question. But what I suspect is you should also then have a lengthy essay attached as additional evidence to this application. I'll show you at the end, where you can plead your case in more detail, because personally, I don't think 2,000 characters is enough for you to explain the entire situation, your entire life, your entire timeline, why and how you arrived in the United States, why you made a choice of crossing the border illegally or, maybe arriving without inspection. You're going to have to explain what circumstances pushed you to that decision. Perhaps your relationship with your U.S. citizen spouse and how it will cause hardship for them if you leave. You're going to have to lay out your entire life and your entire heart. Towards the end of this application, they will ask you if there is an interpreter or preparer assisting you with this form and provide their credentials here. Finally, let's talk about evidence. First, you're going to have to prove your identity, which means you need to upload a document that has your photo, your full name, and date of birth. It can be a driver's license, it can be a biographic passport page from your home country. It can be any other identity document, school-issued document, and it doesn't have to be current. It can be expired. Next, you're going to provide proof of your relationship to your spouse, or if you were a stepchild, to your step-parent, one of proofs of their citizenship. Then, the relationship documentation, which means a copy of the marriage certificate. If you or your spouse have been married before, you also will need to provide documentation of that. So official divorce decrees or maybe death certificates. And then if you are a stepchild, you will need to upload your birth certificate as well. And one interesting thing that I noticed here is you will notice right here, it says death certificate of your U.S. citizen spouse or U.S. citizen step-parent or non-citizen parent if applicable. To me, this says that you may still be eligible for this program if you were married to your U.S. citizen spouse before June 17th, 2024, even if they passed away. Next, you're going to have to prove to them that you indeed have been present here for at least 10 years. This requirement only applies to undocumented spouses of U.S. citizens. You will notice that stepchildren do not have to have been present here for 10 years. As long as they have been present here before June 17, 2024, and as long as they were under 18 when their undocumented parent married their U.S. citizen step-parent. So, evidence of continuous physical presence is the biggest piece of this application because you're going to have to dig up a lot of records from your life showing that you have indeed been living here for at least 10 years. They do give you some ideas of how to accomplish this. Any rent receipts, leases, utility bills, any tax returns, but this may be a difficult thing for you to prove if you have been filing taxes under someone else's social security number or name. School records, any hospital or medical records, any other official records from your church or any other group or organization that you have been part of, any attestations, so that means affidavits from other people in your life from different organizations that can, under penalty of perjury, attest that you indeed have been here, and any other documentations, money orders, receipts, money sent out of this country, maybe birth certificates of children born in the U.S., any kind of bank transactions, receipts. They do give you a pretty good list of things you can use. They do say that you do not need to submit documentation of every day, week, or month within that period. You can upload as many documents to your online application as necessary. They will also ask you if you have any dispositions of any criminal records, and finally, any additional evidence you want to submit. And this is where you can upload that long letter addressed to USCIS explaining your circumstances, explaining why you should be eligible for this program. I think this is where you should upload that additional letter, because the 2,000 characters that they gave you in the form is probably not enough. Finally, they will ask you to check your application, pay the fee. They will ask you to sign it. In this guide, they are not talking about what the fee is, but on this page, they do say that the fee is $580. So once you submit your application, you then will be able to track it in your online USCIS account. Keep in mind that probably thousands of people who are ineligible for this program are still going to apply because a lot of times people don't read the full instructions or they don't understand the eligibility process. I suspect that the processing time for this particular application will be very long, so don't be surprised if you don't hear from USCIS for a very long time on the status of your application. So a couple of more things that I wanted to note, and they did post it on the frequently asked page about this program. What happens if after you apply and your parole request is under review? What happens if you are encountered by Customs or ICE? Will you be placed in removal proceedings? And they do kind of give you a roundabout answer, but basically USCIS, ICE, and CBP are independent agencies from one another. Your applications with USCIS do not protect you from any process that ICE or CBP may begin against you. Same applies to the denial of this application. If you are denied, they can exercise their right to refer you to ICE for deportation. So this is the news that we have so far. All the best of luck to you. Let me know if there were any updates in your case, and I hope to see you guys in my next videos.